Hey everyone, welcome back to another episode of the Ask Amity Show. Thanks for joining us today. And we want to talk about the difference between a conservatorship of the person and the conservatorship of the estate. So previously on the Ask Amity Show, we talked about Britney Spears and her conservatorship case involving her father and her sister. Today, we're here to explain to you the difference between the conservatorship of the estate and person. So the conservatorship of the person means that the conservator of the person cares for and protects a person when the judge decides that the person cannot do it. The conservator is responsible for making sure that the conservatee has proper food, clothing, shelter, and healthcare. Depending on the conservatee's ability to understand and make decisions, the conservator may need to make important medical choices for him or her as well. This would apply to adults who are 18 and older, as you would set up a guardianship for minors.
And a conservatorship of the estate handles the conservatee's financial matters, like paying bills and collecting the person's income if the judge decides the conservatee cannot do it. Just an important kind of side note, even if you are appointed as a conservator of the person, that does not automatically make you the conservator of the estate. If you would like to be both the conservator of the person and the estate, you must petition to be appointed as both. If someone is a conservator of the person and later decides that he or she needs to also be appointed as a conservator of the estate, he or she can file a new petition for conservatorship and at this time request to be appointed as a conservator of the estate.
So for example, if your grandmother is diagnosed with, say, Alzheimer's, and she can no longer make her own medical decisions, you would step in as a conservator and petition the court to be appointed as the conservator to be able to provide the necessary care for her, such as giving her shelter and proper food. If she has financial accounts, properties, cars, or other assets in her name, having conservatorship over her as a person won't be enough. You will also need to petition and apply to be the conservator over her estate.
Also, just to keep in mind, just because you have this conservatorship over a person or over their estate, he or she does not necessarily lose all rights to make certain decisions for himself or herself. This would be determined through the court and for the judge to decide what rights still remain with the conservatee. Some of the rights that conservatee may still have are perhaps the choice to get married. So that choice may still remain with the conservatee if the judge has determined that he or she still has the capacity to make that decision. Also for the conservatee to be able to make a will or change a will, maybe have his or her own independent lawyer to represent him or herself. The conservatee may also have the right still to maybe request a change of the conservator or end the conservatorship. So these rights may still remain with the conservatee, even if there is a conservatorship over himself or herself. Thank you for watching, and we hope that this was helpful and some information to give you some guidance on conservatorships. If you do have additional questions or you need to discuss this with us, feel free to call us and schedule our free 20-minute consultation. Thank you again for watching the Ask Amity Show, and don't forget to subscribe to our channel. Bye-bye.